in Liverpool. It's a bit more windy than last time I came, but it's an absolute pleasure to be here. I'm really grateful for this opportunity to present really the results of my project that I've just finished. It was an ESRC project in which I've been looking together with a team of people how the European Court of Human Rights determines damages for human rights violations. And really here I'm thinking about pain and suffering, right? So how we are compensated, or victims of human rights violations are compensated for their pain and suffering. So it's a project we've been working on for about 3 years. And what I'd like to do in the talk today is really situate the article in the larger project, to tell you what the aims of the project are, then to say a few words about the different theories that apply in the area, tell you what the results of the project are, and then sort of think about what the implications of those results might be for going ahead and for what the court is saying it's doing and what it really does. So when you look at an ECHR decision, and I expect, we've got students here, we've got people who teach it. For me, most of the time when I read an ECHR judgment, I sort of stop at the part where it says there's been a violation or not, right? You don't really read forward because there's very little afterwards. Now, for the last 3 years, what I've been doing is I've been focusing on that part that comes after the violation. So when you look at an ECHR judgment and you scroll down to the end of it, you get to the Article 41, which is called just satisfaction, right? And when you read those few paragraphs, or really lines, they're not really paragraphs, this is what it usually says. And the first line says, the applicant claimed an X amount of money for compensation, right? 10,000, million, whatever. So that's the first line. The second line after that says, as a rule, says the government contested that amount, full stop. And then the third line says, ruling on an equitable basis, the court awards the applicant X amount of money. And that's where the whole thing stops. So there's no explanation, there's no reasoning provided on what basis the court, the European Court of Human Rights, awards damages for human rights violations. So when you read the judgment, you have no idea if that compensation is adjusted or determined on the basis of the violation, if it has to do something with the victim and who that victim is appearing in front of the court, if it has to do with the state, who's the respondent state. Essentially, we simply have no clue, right? Coming in front of the court, we have no clue to understand how the amount of compensation is derived at, whether it was disputed in the deliberations, whether there was discussion between judges about it, and whether the different judges might have different views on it. So what I've been doing together with a team of people then for the last 3 years is we've taken 12,000 decisions of the European Court of Human Rights. So 12,000 decisions in which there was a violation between the year 2004 and 2016. So we're covering 13 years. And we've statistically, empirically analyzed those cases, pulled out the different variables, about which I'll talk about, to see what kind of elements of the case drive the determination of damages. So in a way, primarily the project is empirical, right? It's a statistical project. But really what I'm trying to do is I'm trying to see if there are principles that we can apply to the determination of damages, a bit like in tort law or in personal injury cases. I'm trying to distill those principles and see what the law is. And what I'm really interested in is, on one side I'm trying to see whether or not there are biases in the court, right? Because in domestic practice we often see that, let's say, race might determine compensation you get or sentences you get, or that other nationalities would determine. So I'm trying to sort of see if that's the case and then move it away. But what I'm really interested in is to understand what the court thinks it's doing, what judges think they're doing in terms of compensation, and then see what mathematics or statistics tell me about what's really happening. And then what I do is I go back to judges and ask them, does this make sense to you? So I've double checked it. So that's sort of my first point, right? This is what we're doing. Now, when you do a statistical project like this, especially with 12,000 cases, you sort of need to put forward, or at least in your head, you need to have these theories. You need to have a hypothesis about what the court might be doing. And I sort of think about my hypothesis or my starting points as, you know, what is the court there for? What is its role? How does it see its role? What are the different theories that are associated with that? And so I sort of start with the theory of individual justice. So when you read an ECHR casebook or textbook, you will necessarily, I think, probably, I mean, we could check, but you would necessarily get the individual justice argument. So the European Court of Human Rights is there for the individual. It's there for the victim of human rights violations. And you can see that in the way the court was put together, in the way it was composed, and in the fact that to this day, even in spite of all the reforms, the court still remains open to any application on human rights violations. So there's no limit. Any one of us within the Council of Europe can bring a claim to the court. And so under this first theory, the individual justice theory, the court is really there for each individual, for each victim. Now, the problem with this approach has been thus far, right, today, that the court has received thousands and thousands of cases. And I'll just give you a number. So between 2000 and 2016, which is 16 years, the court received 741,000 individual complaints. That's on average 44,000 cases annually. And keep in mind that we only have 47 judges on the court at any given time, and they don't sit alone in all of the cases, right? You know, often they need to sit together. So what this effectively means is that the court, and that means the judges, are overwhelmed, right? You've got so much case law coming through that it's just impossible for the court to be able to look at each one of those with the time given. So over the years, there has been a number of series, a number of reforms proposed to move away from this, to sort of address the overburden, the big overload that the court is facing. And so that brings me to my second theory, which is the theory that is based on reforms that have been put forward, which argue that the court shouldn't be there necessarily for each individual case, victim, but that the court is really a constitutional court, right? So a court is there to develop the law, the European Convention of Human Rights law. And so in that sense, what the second theory, and here we've got Simon Greer, Louis Wilkhaber, and a number of other people, right, who talk about the fact that the court should be able to pick and choose its own cases. Right? It shouldn't take every single case, every single victim, but it really, like the Supreme Court of the United States, should have the opportunity to say no to the majority of cases and pick those that are going to push the law, expand the rights, let's say, as far as that is possible, and reinforce those rights. Now, we've got these two theories, right? What do those theories mean to me, studying damages? So the first theory, I would expect, would sort of focus my attention to the victim, so to the variables related to the victim. Is the victim the one driving the compensation? In the constitutional justice context, what I would expect is that the court is really, or if the constitutional justice theory applies, I would expect that the court is really giving emphasis, weight, in its approach to the right in question, right? To the violations, to the right in question. And then I get to a third theory. And the third theory is really a theory of recognizing that the European Court of Human Rights is really an international court, right? That it's there as a court of last instance, and that there's many courts that come in line before it. And this is really the theory put forward by Harold Coe, who talks about the transnational legal process, about how domestic courts need to come first and enforce international rights or human rights. It's the Anne-Marie Slaughter argument of dialogue, right? Where she talks about, international courts being there only later. It's the Lawrence Helfer argument of embeddedness, so where the European Court of Human Rights is embedded, but it really comes only after subsidiarity, margin of appreciation are applied. Now, we've really shifted from thinking about the victim, then thinking about the right, to a third theory where the focus becomes one of looking at the state. So the embeddedness theory and the different authors really talk about paying attention to the state and what that state needs to redress human rights themselves, right? To redress human rights violations on its own. So what does the state need? What kind of guidelines can be provided? What kind of remedies would help it fix the problem on its own at home? So for me, these three theories are theories that help me identify my variables, right? And so my first question on the basis of first theory is, does the court focus on the victim? And is the compensation in terms of pain and suffering driven by victim variables? The second theory focuses on the rights violations. So is compensation driven by right-related variables? And then the third one is, does the court look at the state and renders the decisions or compensation on the basis of who the state is? And so my main aim is really to see which one of these applies in the context of just satisfaction, and what the court again says is doing. So then I get to my results, right? And I'll take them in turn. So when I look at my expectation when I started the project was, I felt, having read quite a few things on the court, I felt that the victim and the individual justice theory is really the one that will explain most of the compensation adjustments, right? So how they're calculated. And so the hypothesis I put is that if the court is following the individual justice theory, then the variables associated with the victim and the characteristics of the victim should really explain most of my data. So what are the variables I look at? One of the things, and the first thing I look at, is the victim's age. So what the court says is that if the victim is very young, or if they're very old, and let's say they're in prison in bad, poor conditions, that kind of young or old will influence the compensation. That compensation will be higher because they suffer more. I look at gender because in certain cases, some of them, violations like rape, are gender specific. Or I'll say that they happen most frequently in relation to some certain gender. Then I look at the vulnerability. I look at the personal circumstances. And one of the things, for example, that I've seen, and again this is in prison cases, is that you've got quite a few individuals who are in wheelchairs or who are otherwise kind of restricted in terms of movement. And the question is, A, does the country make any adjustments for them? But B, when the court is determining compensation, will it treat these vulnerabilities as an element that should determine or affect damages? The third thing I look at is what the impact of the violation is. So has a person suffered serious consequences? And I've had a number of cases where in protests people have had have lost their limbs, and things like that. So would that kind of impact of injury, serious injury or death, affect the damages? The next one, the next variable I look at is whether or not the victims appear on their own, so as a single case I call, or in a group, right? When we've got multiple victim cases. And there I look at, the number of people in a group, and I look at that because I wonder if there is a distinction in terms of how the court treats multiple violation cases versus one case. And then the final variable that I look at is how the victim, so the victim appearing in front of the court, what kind of number they put on their pain and suffering. Yeah? So does the victim appearing in front of the court think that their pain is 80 million euros worth? Or do they think they can't put a number on it and it's like €1? And I've had cases on both sides of the spectrum, right? We've got individuals coming and saying, I can't put a price on my dead son, and therefore I will claim €1. So that kind of how they assess the pain and suffering is important, because previous studies have shown that when you put a price on something, you've set a ceiling, right? You've set a ceiling, that's one thing. The second thing is that previous studies have shown that the more you ask for, the more you'll get. So there's what we call the anchoring effect. When you speak to judges, so I've sort of told you the variables, and then I can tell you what I found out from interviews, which is when you speak to judges, they say that from their perspective, compensation for pain and suffering is about the victim, right? So they think that this is a symbolic way of acknowledging their pain and suffering, but it's there to compensate the victim, the specific victim appearing in front of them. So, what is the result? When I put all of these different variables into the regression analysis, what becomes very clear is that most of these variables don't explain any variability in the data. What that effectively means is that none of them, apart from one, is significant. So in another way, who the victim is that appears in front of the court appears to be completely irrelevant. So if you have lost a limb versus someone who hasn't, that makes no difference. If you're old or young, that appears overall to make no difference either. If you are particularly vulnerable, that appears to make no difference either. The only thing that appears to make a difference is whether or not you made a claim for compensation or you failed to, but not what kind of amount you put on that claim. And the second variable that appears to make a difference is whether you appear on your own or in a group. Now, what's your guess? Is it better to be in a group or on your own?
I know, I read the paper.
Oh, you read the paper? Yeah.
Probably in a group.
So you think if you go in a group, you'll get more per person?
To me, it would sort of give an indication of gravity, in a sense.
So in a way, a group case shows systematic problem, and therefore, yeah.
More serious.
Yeah. So it's the reverse. It's if you appear on your own, you get more compensation than you do if you appear in a group. And I asked the judges why. They feel that if you appear in a group, you in a way share the pain, and therefore there's less of a burden on you to present evidence. And so the compensation is lower. I mean, there's another element that I'll mention when I get to my third part. That plays a role, but there is you get less. So appearing in a group doesn't, I mean, it might work for you because you're appearing with that group and they all have the same probably circumstances, but it doesn't in terms of compensation. So what becomes very clear is that the victim per se is not relevant. Even more, So compensation, even in these group cases, is not individualized. There appears to be no or very few cases in which a distinction is drawn between people appearing in the same group. So essentially, my first theory doesn't hold, right? So the victim isn't relevant to compensation calculation. So then I get to my second theory, which is the right, the one focusing on the right. And so my expectation is that compensation will be driven by the violation, right? So what happened, and then that will determine damages. And here I'm thinking Article 3, torture, and then I distinguish that from inhuman and degrading treatment, inhuman treatment, degrading treatment, right? So I sort of separate them. Then Article 2, is it death? Is it intentional killing versus other types of killing? Article 5, each one of the right articles separately, then etc., right? So I really distinguish it. I don't just take the whole article together. So what I expect here when I'm thinking about it, I expect that there will be a hierarchy of rights, right? Because when you look at the convention, when you ask people teaching it, everyone will tell you there's a hierarchy of rights, right? And the prohibition of torture you would probably put on top, right? Right to life, prohibition of torture. And so I expect that in terms of compensation, a certain hierarchy will come out that follows that ranking in the convention. The second thing I expect is that damages will be awarded regardless of whether or not the person has made a claim, right? So that even if they didn't make a claim, because you've got this right in question, you'll get a certain compensation. So what do I find? What becomes very clear is that the type of violation is important, right? So you get 20,000 for torture, 20,000 euros per every event of torture, but you get 2,800 for degrading treatment. Right? So I do get a sort of a menu out of the calculation. You get inhuman and degrading treatment is about 5,000, but then inhuman treatment on its own is about 1,800. So you get this hierarchy. But what's really interesting within that is that there's, within each article, there's a certain type of behavior or conduct that's singled out as really bad. And then there's the rest. So in Article 3, torture is considered to be, special stigma attaches to it, and so it's put there. But then every other type of behavior is sort of close by. So if within Article 3 a state fails to conduct an investigation, that's sort of the same as if you're beaten up, but it's not torture, yeah? So it's sort of, there's very little distinction unless it's torture. Same for Article 2, right? Excessive force up there, but then sort of. So it means that there's, within each one of the articles, there's a certain type of behavior that the court thinks is especially appalling or especially bad versus other type. So that's sort of the first finding. The second finding is that so there's a sort of hierarchy, right? But the second thing I thought is that there would be a difference between substantive rights, right? When I say substantive, I mean, right, when you've got, rather than procedural, right? So procedural, Article 6, Article 5, and then let's say substantive Article 2, Article 3. So I thought that substantive violations would bring more compensation than procedural. But when you look inside, what you find is that within non-pecuniary damage, procedural rights seems to attract more compensation, generally, than substantive. For example, Article 6 will bring more compensation than substantive parts of Article 5. Within Article 3, so torture and human degrading treatment, unless it's torture, failure to investigate will bring more compensation than degrading treatment or than being punched. And this is quite significant, right? It's consistent that I find this. And it wasn't clear why procedural violations would be specifically worse than substantive. But what seems to be the case is that the court is a bit more sensitive to violations that indicate a problem inside the state, a systemic problem. So then the third thing I find is that there are certain cases in which, regardless of whether or not you feel you are entitled to compensation for pain and suffering, the court will award you compensation nonetheless. Right? So there's a number of cases in Article 2 and Article 3 cases that even if you didn't make a claim, you will get compensation. That goes completely against rules of international law, right? That unless you make a claim, you won't get compensation. So the court appears to be, especially in cases where you've had a bad lawyer, you've got a complaint against your lawyer, that you will get some sort of damages. So that's my second theory, right? So the second theory seems to be more relevant. And then we get to the third, right? And the third theory is the theory that looks at the extent to which compensation is determined by variables related to the state. And there are a number of things I look at. First, I look at who the respondent state is, so who's being sued. So is it Turkey, is it UK, is it France? And then I categorize them. Is it the old states who have more money, new states who joined after 1991? And I'm particularly concerned about the GDP, right? Because the court is saying that there's something happening there where the compensation is adjusted. And then the second thing I look at in this context is the number of cases that I have in my cohort against that country in relation to the same article. So I'm interested how many times Turkey has tortured someone and whether or not that will influence next time around the compensation for torture against Turkey. Does that make sense? Right. So I want to know whether or not the fact that you're a repetitive violator affects the compensation you're going to pay next time around. Because there are voices inside the court that says the more a country does something, the more it should pay. We should teach it, right? So I wonder if there's an element that's punitive of damages. And so what do I find? The first one is that who the country is it Turkey, is it the UK, is it France, matters. So torture by UK will cost more money or will bring a victim more money than torture done by Turkey. And the difference is, so on average Turkey pays 5,300 euros less for the same type of behavior than the UK. 5,300 euros less. Right? And the adjustment is made, at least that's what the court says, according to the GDP. Right? And the aim is to ensure that the people have equal purchasing power when they return to the country. So essentially torture doesn't cost the same everywhere in the Council of Europe. So that's the first thing I find.
Sorry, can I ask you something?
Yeah.
If I may. You mentioned whether the problem was if you're a repetitive violator as your starting point in the hypothesis.
Yeah.
And here you're suggesting, but I may have misunderstood, that the difference is largely due to the fact that there are different GDP and this is...
So I
can't put the two together.
I'm testing the two things, right?
Okay,
so first
sorry.
one is who you are,
Yeah.
and the second one is are you repetitive.
Okay, sorry, I missed
And on
that.
who you are,
Yeah.
Turkey pays 5,000 euros less.
Yes.
Now on the
I
repetitive,
see.
yeah.
Thank you.
So by far the most interesting results I get are on the frequency of the violation. And so my hypothesis is that the more you do something, the more you'll pay. Yeah, because that's sort of one-on-one economic analysis, right, or economics Also, if you want to change state behavior, you make, or behavior of individuals, you make them pay, they'll think about it next time, the cost will be higher, they'll say, okay, no, right? So you want to maximize the deterrent effect. So a few things, what do I find? For Article 2, right to life, every time a country does it, for every case, next time it pays 300 euros more. This is Article 2. For torture, or for Article 3, every time a country has an additional case, it pays 23 euros more next time. 23 euros. Yeah. And for Article 5, every time a country gets a new case or violation, next time around, it pays 15 euros less. So the more you have, the less you pay. Now, you need to keep in mind that I'm not talking about one case and therefore next time it will really be 15 euros. I'm talking about 200, 300 cases by one country, which means you need to multiply that 15 by 200, and we're already in 1,000 euros less just on that element next time around. So, what does this mean? Right? Because this doesn't make sense when I saw it. Like, why would compensation go down the more cases you have? If you're a systemic violator of human rights, I would expect the court to push that compensation up. And I went to interview judges and to ask them. I asked them about this element in particular, and about the group element, if you'll remember from the first theory on the victim, where the more victims there are, the less they get, and on that, for every additional victim in a group, you get 88 euros less, right? And then you need to multiply by 50, because usually it's 50 cases, so it's a considerably less amount of compensation. Now, what the judges said is that, so the sort of the information I got was different depending on who I interviewed. The younger judges, or judges who had joined the court, did not know that there was this sort of lowering of compensation. Judges who had been at the court for a longer amount of time said that they were aware of this. And their position was that the concern is really one of compliance. So we are lowering compensation in these group cases or in repetitive cases because we're concerned the countries won't be able to comply. They will not be able to pay. And the case that everyone mentioned was the Burmik case against Ukraine, where you got about 20,000 cases against Ukraine for a violation of Article 6 procedure, essentially failing to implement domestic judgments. And for that violation, in 1999, compensation for that violation was 5,000 euros. Today, that compensation is 1,000 euros. So the same violation costs about a fifth than it did before. And so one of the judges said that effectively what's happening is that they're giving a discount on quantity. As I said, this is completely counter anything that you would expect in terms of sort of thinking about this as an economist, and it goes completely against the fact that if we want to deter future behavior, future repetition, this shouldn't happen, right? So where does this leave us, right? So the first thing is that the victim is irrelevant. We've started with the victim, but in terms of compensation, the victim appears to be irrelevant. Number two, the second hypothesis was that the violation and the right are relevant, and that is true to a certain extent, but what's become very clear is that certain rights, like procedural rights, which can be quantifiable, and here I mean Article 6, where you can count the number of years that proceedings have lasted, those cost more than a number of substantive rights. And then the third conclusion that I find from my third model is that the court is very much motivated by compliance and by enforcement. And when I started this, I didn't expect that Article 41 would be driven by that concern. Because generally, concern is, in terms of compliance, is put on other non-monetary remedies, right? It's about changing legislation, it's about giving very strict instructions to the state, and that's why the court doesn't do it. I didn't expect that compliance would play a role when it comes to compensation, especially because compensation is quite low if you think about it, right? It's about 10,000, 5,000 euros. So the problem that arises from these results, there are a few. Number one is that, you know, there are countries that appear in front of the court that I'd say are frequent guests of the court. And those countries have seen, so there are tables that, on the basis of which the court determines damages. And the countries have seen those tables. So they know what's coming out, how much something is going to cost. And I'll just give you an information for Russia, right? So Russia has a line in its budget that is dedicated to paying off non-pecuniary damages for human rights violation. It's not for UCOS, it's not for the big cases, it's for these kind of cases. And that budget has gone from 1.7 million in 2010 to $7.6 million in 2016. So they've increased the budgets for paying compensation. Now, I'm not saying that Russia is planning on, committing human rights violations. But what the current approach of the court is enabling it to do is to plan how much it's going to cost. So Russia knows what's coming out, and it knows how much it's going to cost. And because it's so low and predictable, it just means you can be ready. So that's one problem, right? The second problem is that there is an interesting dialogue or lack thereof between the judges and the registry about how compensation is determined, right? Because compensation comes at the very end of the proceedings. Often judges are sort of,